Greetings. In the last mini lecture, I talked about the era of Jim Crow, which I take a little bit broader view of Jim Crow than a lot of professors do in their classes. When I was a student, for example, my professor talked about Jim Crow as merely being legal segregation. Certainly, I think that's at the core of Jim Crow. And even though there were thousands of Jim Crow laws, I told you I really wanted you to only know two of them. The civil rights cases of 1883, which allowed private discrimination in places like bars, restaurants, theaters, ice cream parlors, funeral parlors, gas stations, etc. And then the 1896 case of Plessy versus Ferguson, which ushered in this new doctrine called the separate but equal doctrine. In reality, it should have been called the separate but unequal doctrine, because while the law was really reinforced in terms of separation, there never was any equality attached to it, and white facilities were always superior to black, or was called at the time colored facilities. So the first pillar of Jim Crow was legalized segregation. I then talked about political neutralization, talked about various devices that disenfranchised black voters that we would today call political suppression or political neutralization. And then the coup de grace was violence, intimidation, not only from the KKK, although they certainly were the poster children for violence and intimidation, but really this permeated Southern society. Now, something this evil is going to result in a political response, and you may remember I talked about pluralism earlier. Remember, pluralism is this belief that government responds to citizens that are organized into groups. And so the notion of pluralism is that if government is unable or unwilling to respond to a problem, new groups will form spontaneously to challenge the status quo and to try to overturn it. So there were several interest groups, there were several responses, the most famous of which is discussed in your textbook is the formation of the NAACP, the National Association for the Advancement of Colored People, in 1909. This new interest group had only marginal victories in the first 3 decades of its existence. The group was able to get the grandfather clause declared unconstitutional in 1915 in a case called the Gwynn case. The NAACP was able to get Texas's white-only primary declared unconstitutional in 1927. But for the most part, this group struggled to make meaningful gains. Now, Thurgood Marshall began working for the NAACP in the mid-1930s, and he ended up becoming Chief Defense Counsel in 1940. Thurgood Marshall had a very distinguished career. He argued 33 cases before the Supreme Court. He won 29 of them. And Thurgood Marshall essentially told the group that you're going to have to be patient. If you think that something as deeply rooted as the separate but equal doctrine is going to be eliminated in one Supreme Court case, then you have another thing coming. Marshall urged a three-stage strategy, and certainly I have that illustrated in your notes if you're following along. The first two cases, the Gaines case in stage 1 and the Painter case in stage 2, I'm not going to test you on them, but I want you to see what I mean by this chipping away. So in stage 1, the NAACP, and this was before even Thurgood Marshall was the chief counsel, he was certainly working there. He had assumed a position of leadership. And in this first stage, the NAACP was going to point out states that were obviously violating their own law, which was separate but equal. And so The challenge in this case was they were going to go to states like Missouri that only provided a facility for white students and none for blacks, or as Thurgood Marshall called them, either colored or Negro. So in Gaines versus Kenyatta in 1938, Leroy Gaines claimed that the denial of admission to the University of Missouri Law School violated his 14th Amendment rights. In this case, the denial of his admission violated the Equal Protection Clause of the 14th Amendment. In this particular case, the claim was that the law is separate but equal, but there is no comparable facility for black students. In this particular case, the University of Missouri has a white law school, but does not have a colored or black law school. And so the Supreme Court in this particular case, led by Chief Justice Hughes, said that Missouri had failed in its constitutional duty to provide equal access to public education. They had violated their own law, and in this particular case, Leroy Gaines prevailed. Missouri was, in this case, forced to build a separate facility for black students. In stage two, and stage one lasted a long time. Thurgood Marshall, throughout the 1940s, went to southern states and pointed out, hey, there is a white engineering school, there isn't a black engineering school. There is a white medical school, there isn't a black medical school, etc. By the end of the 1940s, southern states saw that the Supreme Court was not going to allow them to provide facilities for only whites, that they were going to have to provide facilities for blacks. In stage two, Thurgood Marshall and the NAACP decide to chip away at the separate but equal doctrine in a more meaningful way by looking at states that do provide separate facilities for the races, but not comparable facilities. So the best example of this would be the 1950 case, the Painter case, Sweat versus Painter. In this particular case, the Texas provided a world class, a nationally renowned law school for white students, and a very inferior school for black students. Thurgood Marshall said, take a look at these two schools and pick any objective criteria whatsoever. The white law school has a nationally renowned faculty. The black law school had only part-time faculty until shortly before this case, when a couple of old white professors were drug out of retirement. Take a look at the law library. It is huge. It is immense at the white law school. The black law school, their library consists only of obsolete old books that the white law school no longer wanted. The black law school had met in two places, in temporary Quonset huts and in the basement of a building. The white law school had immaculate grounds, immaculate buildings, state-of-the-art facilities. There were modern mock courtrooms for law school students to practice, to prepare for their future career in practicing law. The black law school only had one old, antiquated mock courtroom. And so Thurgood Marshall said, in this particular case, we will acknowledge, we will stipulate up front that this case is different than the 1938 case of Gaines versus Kenyatta. In that case, there weren't separate facilities. Gaines was asking for admission to the white school because there was no black facility. In Texas, there are separate facilities for the races, but they are not comparable. The law in the state of Texas is separate but equal. These law schools are not comparable facilities in any way. And so the Supreme Court unanimously, 9-0, ruled that in this case, Mr. Sweat must be admitted to the University of Texas Law School. Unfortunately, the stress of 4 years of litigation did not do him very much good. As it turned out, his health deteriorated. He started getting poor grades. He ended up getting a divorce. His wife ended up leaving him, and he ended up dropping out of the University of Texas Law School. If I remember the story correctly, and I might be a little bit vague on this, I believe he ended up completing a degree in social work and later went and did a little bit of work for the NAACP. So certainly this was an important case. But notice how Thurgood Marshall and the NAACP are trying to build up to overturning the doctrine. And so in stage 3, we finally get to the landmark case, the case that I want you to remember, Brown versus the Board of Education. And this will be the focus of the next mini lecture. But before I do, I want you to realize what a long ordeal this had been. Gaines versus Kenyatta occurred in the 1930s. We finally get the Painter case in 1950. By the time 1954 rolls around, Brown versus the Board of Education was really the climax of a 16-year effort to overturn the separate but equal doctrine. Now, there is a little side story here that I want you to know leading into this case. Thurgood Marshall was ready in 1952 to take Brown versus the Board of Education to the Supreme Court. But the Chief Justice, Fred Vinson, refused to put it on the discussion list. You remember I talked about that earlier. He refused to hear this case. He said, we've gone far enough with civil rights. We need to allow southern states some time to adjust. Chief Justice Vinson was from Kentucky. He wasn't too keen on civil rights. And then, of course, history intervened. Fred Vinson had a massive heart attack while eating dinner and died. Remember, this led to Felix Frankfurter's famous that the death of Fred Vinson is the first positive indication I've ever had that there is a God. President Eisenhower nominated the governor of California, Earl Warren, to be the next Chief Justice. And Earl Warren comes to the court with guilt. You see, Earl Warren was the Attorney General of California when President Roosevelt, during World War II, issued Executive Order 9066. Executive Order 9066 resulted in the internment of Japanese Americans into internment camps all along the West Coast. And it was Earl Warren, as Attorney General, who enforced that order. He is the person who enforced Executive Order 9066. And Warren felt tremendous guilt for doing this. He later said he should have resigned in protest and allowed someone else to do this. And so Warren felt tremendous guilt for participating in this great evil in American history. And so Warren pledged that if ever given the opportunity, he would right the wrong. And so the stage is set. It's 1954. And now Earl Warren has the opportunity to right the wrong. In this particular case, in Brown versus the Board of Education, we are going to get this legal landmark case in which the Supreme Court is finally going to overturn the separate but equal doctrine that was established in Plessy versus Ferguson. And I will talk about Brown versus the Board of Education in the next lecture. Have a wonderful day and be safe.